Go ahead, continue.
Turning to my last submission, I submit that environmental due diligence is a conduct standard linked to the no harm rule. It is an obligation which entails not only the adoption of appropriate rules and measures, but also under a certain level of vigilance in their enforcement and the exercise of administrative control applicable to the public and private operators, such as the monitoring of activities undertaken by such operators to safeguard the rights of the other party. And such rules and measures must be in accordance with any applicable international agreements and in keeping where relevant with the guidelines and recommendations of international technical bodies. In short, this is an obligation of means, not of absolute result. Hence, if a state breaches this duty, it fails to take reasonable preventative measures and uphold standards of due diligence. In the International Law Commission's draft article on prevention of transboundary harm, Article 3.7, and its commentary, the prevention via regulatory, administrative, and enforcement measures due diligence does not guarantee that harm will never occur. It is in how they enact the law in order to ensure that it is adapted to the context and capabilities of the state involved in order to prevent and protect any cases where they may be harmed. And because this due diligence does not guarantee total avoidance of harm, it only requires states to act prudently in light of available scientific knowledge, technological capabilities, and legal frameworks.
Agent, doesn't that mean that it's very hard for us to really measure if a state has in fact complied with the no harm principle or not? Like, wouldn't it be impossible for us to determine?
Your Excellencies.
Is there objective standards that we can follow?
Your Excellencies, in this practice, the duty requires the EIA, also known as the Environmental Impact Assessment, the effective legislation and licensing to control any risky activities, the ongoing monitoring and information sharing, as well as the cooperation and administrative vigilance and enforcement upon other states' private operators, as well as the mitigation and adjustment as science and standards evolve. So this is rather not a strict liability, but a reasonable and proportionate measures to foresee any harm that still occur if the conduct may still satisfy the due diligence. So conversely speaking, if the omissions or failure to warn, to assess, to monitor, or to control the known risk, it is a breach that it is considered a breach even before the damage has occurred. Back to my submission. This permits the reasonable management of environmental risk by recognizing the practical limit that state must face. For example, a state is not liable for any unforeseeable damage or harm that may be caused by third parties who act fraudulently without the state's knowledge or consent. And the obligation here captures a variety of state measures such as adopting effective legislation, supervising private operators, and as such, the states are also expected to cooperate in good faith to address or mitigate any transboundary environmental harm. So, in conclusion, the no harm rule here constitutes a binding norm of the CAL, imposing a due diligence obligation on states to prevent any harm, and this rule requires states to enact and enforce any reasonable measures based on current scientific understanding. This is far beyond an absolute guarantee against environmental damage, and the due diligence standard balances sovereign rights with responsibility.
Agent, doesn't that mean that environmental protection in this case is then limited only to economics? So for continents where there are a lot of countries of poorer stature, they're not able to prevent a lot of these harms.
Your Excellencies, this links back to my principle, the no harm principle. Although it is not a binding principle in the ICJ court, we also have the CBDR principle, also known as the common but differentiated responsibility in cases where a developing state and a developed state has an issue in regards to any environmental transboundary movement.
So, so the principle is the same, but the effective action based on that principle can be different.
In this case, between the effects of a developing nation and a developed nation, the developed nation, under the belief that they have more economic and finance status in comparison to the developing nation, the developed nation are expected to step out to help and mitigate in finance or legislative measures, or take legislative measures. Your Excellencies, if I can assist the court any further, I would like to conclude my submission.
Okay.
Thank you, Agent.